you're just starting.
Oh, okay.
Okay, perfect. Thank you all for coming. Today is June 11th, and I'm calling this meeting to order. I'm Andrew Ferrer, the Chair of the Tenant Landlord Commission, and we do have an in-person forum. I want to acknowledge Commissioner Reynolds, Samala, Copel, and Tim are present. And one excused absence of Commissioner Lang. Moving on with our agenda, the first item is public comments. First up is Cody Link, who addressed the commission last month. Cody, you're going to come to the table. You have 3 minutes.
Great. So I just want to follow up. Again, I think I was discussing with members prior to the meeting that in full disclosure, I didn't realize that meetings were recorded for public consumption, posted on Google. That all being said, I have shared some materials with the commission that you guys have up to review. And again, I think, like I said before, we've tried to exhaust a lot of avenues for help and support in the community, especially from the local government in support of the affordable housing issue with the landlord that seems very intent on having us be vacated from affordable housing, which does not seem like the spirit and intent of the agreement with the town. I think, like I said, we've been in touch with code enforcement. We've been in touch with the Arlington Affordable Housing. We've been in touch with the Human Rights Commission. And I think the county manager's office. Sorry, and the county manager's office. Sorry. So I'm happy to entertain any questions, but again, like I said, this is a new and last arm of the government that I'm aware of that I haven't touched in some way to ask for help in helping solve the issue with my landlord. There retains to be a maintenance issue, and we continue to pursue us in court, and we violate rules of procedure in that process. So that's where things are. And I'd love to learn more about what the committee could possibly do and if they have any sort of regulatory or oversight mandates of that nature. I'm very interested here. And I'm willing to share more, but again, I'm cognizant of the fact that there's ongoing litigation and of, FOIA requests and redisclosure of things to the public. So that's something that I am cognizant of. Awesome.
Okay. And just to give commissioners an update, we did receive the files and we did review them, and we did inquire with county staff as well as code enforcement. As you know, code enforcement is more of a black box, and we don't get too much information out of them. We did hear the noise you did reference on the call. I guess we're quite limited because you are engaged in judicial actions with your landlord at the moment in time. Has the landlord offered you any viable solutions, such as switching your apartment, moving into a different building that's nearby that's equitable to your current domicile?
Sure. They have not offered us moving to another building. They, after 9 months, I think, say right before the non-renewal, had suggested a unit. I think that's below or two below us. But we did review it. I asked for them, again, like I said, we have maintenance issues. There's a lot of maintenance issues with this part of stepping in and unoccupied. I think I asked, is this something that could be remediated, or if this doesn't work for us, do you have something else that might be available? And then I think the next correspondence I got was, here's one. So the short answer is yes, sort of, but it was kind of difficult to, if I'm being frank. It seems to me that there are certain apartments, again, I'm not a specialist, I'm not a lawyer, I distribute a doc. As far as I know, to my understanding, there's no specific units that are supposed to be earmarked for it. There's only a certain count. It's my understanding. And so it seems to me that they have vacancies and they're only interested in affordable units being in certain units, which to me feels like a violation of spirit. But or that they have possible knowledge that that's defective and here we're going to take it from one term and put it in the same or worse unit. And again, if it's a piping issue, it's vertical, so that was also a concern. So to your direct answer, no, they didn't offer us anywhere else outside the building. There was one unit offered after 9 months that we stipulated we had some concerns about. Is there any other units? And with full knowledge that there are other units available, I said essentially violations.
And you're represented by counsel right now, right?
Right now, no. So we're still.
Have you contacted legal services in Northern Virginia?
I have great experience with this service. Some intake on secondary, new intake, create new parameters, and assuming been responsive. But even the first time when we tried to go legal services to Northern Virginia, I'd asked them to represent me, and they kind of were cagey about it. And eventually pushed me to shove, they wouldn't represent me, which I was confused by, setting budget, limitation, things of that nature. Which is also extremely confusing because they represented someone else in my building against my brand at the same time. So that's all very confusing, to say the least. So, you know, in my experience, it seems that they're a good service for the community, but I personally have not experience or have received any benefit from them.
You reach out to any other similar services?
Oh, yeah. Feel free to list any off. I'll tell you if I reached out. Yeah, Home, who's supposed to be here presenting today. Others, again, I don't want to.
And they're just not taking your case?
I think generally speaking, I've been told that there's no budget or capacity for it. Which
Should we at least offer you legal advice, or at least do a consultation rather than represent you in court?
legal service did that the first case, the second case, I had responsible asked, we wait for a couple weeks, so I should call them back. But in my experience, they are trying. If I can read behavior writing on the wall, they're not going to. But it seems that there's a general unwillingness in the community among NGOs, not-for-profits, overseas pro bono type entities to have any sort of representation of all this. I think this was a concern. I think I shared prior to the formal meeting that it is strange how many organizations seem to exist that don't seem to be doing things they seem to say they are supposed to be doing. So that's been disheartening and just
Any other questions?
I know one of the follow-ups we had was to ask about code enforcement and timing. Did we get any response on that?
We got a tertiary response. Karen, correct me if I'm wrong. One is ongoing and the other was closed.
So I guess there was some. If there was two. One. There were two things that I worked on clarifying.
Yeah.
That more.
I should add that I did get I did get contact out of town, so I was only I got in touch later in the week, but I was contacted by a member of code enforcement earlier last week, if I'm speaking correctly, but I was contacted by them. They left me a voicemail. I called them back later, went to voicemail and said, text me, I'll call you later. They said, oh, you know, and I said, oh, following up later. Oh, that's the wrong number. Is sure you're not following up on anything? And they said, nope. Or I don't know if they said, no, just didn't respond. I was like, great. So that's outstanding with no progress.
So we can follow up with code enforcement again.
Yeah, I don't, again, like I said, I'm not here to get any trouble. I'm not here to make a mistake. I just feel like we're being targeted by a member any precarious financial position as in a protected type vulnerable housing situation. And we've looked for help in any sort of way. And I think we've gone way out of our way to do that. And any anytime that anyone's seeming to start to get involved, they get discouraged by the landlord for some reasons. Most of the time they won't share, and sometimes they do, and it's surprising what they've got to them. So that's kind of, and again, I'd love to hear about what parameters you guys can help in, if you're able to share. But, you know, it seems to me that the legal system is set up such that they can sue you indefinitely to keep any, if the government won't do anything so long as there's ongoing litigation. That's also concerning. That means that that's a carte blanche for companies to do whatever they want.
They can do what? I'm sorry.
If it seems to me the only real feedback that I've gotten in some cases where that I might have been told I might get help or intervene intervention is that if there's ongoing litigation, that they can't do it. And so that's concerning because it seems to me that the way the chain of force is set up, they can just keep suing you. So as long as they keep suing you, that the county or the government won't do it. And that seems like, that just seems not right.
In this case, remind me.
So in this case, for example,
I'm sorry, Hannah. Did you sue?
So I haven't taken any offensive legal action despite the fact that I maintain that I do have rights to.
Right.
And have.
And they're suing specifically for non.
They're suing for none. So they want us out. They continue to accept grants. There's no seeing nothing.
And you've not withheld rent at all.
I think we went over this last time where there was a period of time where there was partial payments of rent, which were accepted without reservation. There's no reservations at all. I also telegraphed the parameters of the law, which why it's being withheld. I telegraphed it before. And then in writing, they just, you know, after just 5-day notices, then they rescinded, creating even more confusion. So they kind of said, oh, that was our fault, you know, and then told me that, oh, we're not going to nominate for this. We've had personnel issues and all this other stuff. We're bringing in someone to fix it.
But there's currently no withholding of rent.
There's never been a non-payment. And there's no withholding of it. Hasn't been for practically a year.
So if I may ask a question, one of the things that I think we heard it last time and right now is that if they have offered you maybe for you to transfer to another unit, and you said they haven't until some time ago, is that something that whenever you reach out to them, they tell you there's nothing available, or have you actually gone to the website to see if what they're saying does not go with that? And my second question to that is, as the lease, if you're the leaseholder of that unit, have you had maybe someone else trying to apply for any unit in that same complex?
Well, I would, so I'll answer your question. The first question, remind me of the first question.
Have you verified, for example, on their website?
Yeah, availability. Okay, so
Yeah.
so availability and testing.
Correct.
Okay, so they don't publish availability of affordable units. So again, like I said, I think they earmark specific units, even though I don't think that's the terms they agree. So technically, any unit, from my understanding, especially because I asked them, that any unit could be deemed affordable. Because especially if you don't qualify, that unit can be deemed in the market after the fact, right? So because you stay in your unit, you no longer qualify for income, and then you pay market rents for the same unit. So to your question about availability, technically it's not published. I don't know. They're, you know, I do know that they have policies in place, and I'm pretty confident that they don't follow those policies in certain scenarios. And I'd also say that yes, there's absolutely availability on the website. Absolutely. And so, and I've had in conversations with management, I was told I could move to a market rate. You know, we could move to us. The problem is we don't have any affordable units available. We have market rate units available, and you can move to them, but you would have to pay market rents. Which seems, again, to violate the spirit and intent.
What?
And about your question, sorry.
No, go ahead.
About your question on testing, I would say that is the job of certain NGOs to do fair housing testing, and they should continue to do that. But I don't have knowledge of any evidence that that's been done. Have I personally applied myself or asked someone else to apply? Yeah, most people can't be bothered to do it. So I don't think, you know, people should apply.
Have you reached out to them? I mean, if you think that's an issue, have you reached out to fair housing?
Yeah.
With a complaint?
Yeah.
An actual complaint?
Yeah, fair housing, to the applicant, it's like a tenant issue. Not a fair housing issue, just concerning itself.
You wish of the county fair housing or state?
Yeah, state. Well, county accepted, fair, state did.
Excuse me, I'm sorry.
Yeah.
This is Regina Cheney. I'm actually going to be speaking or presenting a fair housing presentation in a few minutes. And I'm hearing bits and pieces, but did you reach out to the Virginia Fair Housing Office? Is that what you said?
Let's take a step back. What was the question about fair housing?
Did you reach out to the Commonwealth's Fair Housing Division?
Yes.
Okay. Yes.
Yes.
Shane.
Okay. And so I would suggest that you contact Home of Virginia. We are a private nonprofit fair housing organization, and we cover the state of Virginia. I know that VFHO, which is the Virginia Fair Housing Office, they're somewhat short-staffed, so I'm not sure what type of response that you might have gotten if you didn't get any, or if things have taken a little longer. So I would say if you would give your name to the host. I'm sorry, is it Carla? Kara, thank you. Give your name to Kara, or give your name, contact information to Kara, or you can certainly reach out to me.
Okay, Miss Cheney, is it?
Yes.
Yeah, I'm happy to do that. I will say that I've been in touch 2 different times. I feel like I want to say I spoke to the deputy director the last time.
Okay.
But I'm happy to follow up.
Just point of order, I'll just allow you to do that.
Sure.
Okay.
And then, if you have no other comments from the commissioners? Well,
I'll just wrap up. You asked about the TLC powers. There are no direct power or arbitrary disputes at this time. But typically, like, we get involved before litigation happens, and oftentimes the parties will reappear at a TLC meeting or offline, and we'll work something out. So unfortunately, like, one of the things about ongoing litigation is they're not going to be they're less likely to be interested in coming to discuss. Most of our powers are soft powers of persuasion and it's related to disputes. Sure. So we can't force the landlord to do something specifically. Sure. But we could consider bringing the landlord in and see if there's a resolution that's possible. So
I'd love for you guys to consider. And also, it would be also useful to hear if more information about letters of objection, maybe that the town might be able to issue from housing. Also, another opportunity that you like where the company might not be a direct power, but indirect through arms to cover. That might be a value or helpful. But like I said, I'm a reasonable person to try to settle things. It seems that again, it's unfortunate. I wish I'd known that in front of you guys beforehand, because I've asked for mediation specifically, and they kind of just so. I don't know if that ship's never was going to sail to begin with, but I appreciate the context and detail.
So Kara, if we could reach out to the landlord and see what the circumstances are, and then we'll proceed from there.
If you could,
24 hours?
yeah. That'd be
Okay.
good. All right, cool.
Thank you so much.
Thank you so much. Appreciate it. Thank you everyone for your time, your help, and research.
Kara, this one is actually else. Maybe that's why she did it. I think she was looking at the wrong floor.
Oh, yeah. And put down her address instead of whoever she was.
Yeah. I mean, we could redirect her to.
She never emailed.
Okay, well, she's out of our list. Is there anyone else on the call that's here for public comment? If not, we'll proceed to the next item, which is the approval of the minutes. Any questions regarding the minutes? Been moved and seconded. All those in favor? Those opposed? Motion carries. Okay, moving on. We have a presentation by Ms. Regina Chin from the Fair Housing Consortium,
No, she's from Home Virginia.
Home Virginia. Ms. Cheney, you have the floor.
All right, thank you, all, and my apologies for speaking out of term. It just seemed like there was a struggle with fair housing, and I was like, okay, here might be an answer for you. So anyway, I'm going to share my screen, and I want you guys just to let me know if you see it. Oh, share, I'm sorry, here we go.
We do, but it's not in presentation mode. There we go.
All right. Well, good evening, all. Again, my name is Regina Cheney. I'm with Home of Virginia. We are a private nonprofit civil rights organization, and we actually, our focus is fair housing. We serve this entire state of Virginia. Our mission is to ensure equal access to housing for all people, and we do that by through our enforcement and investigation team, which is basically our fair housing team, where we investigate instances of housing discrimination, systemic housing access, and we also litigate. So I say we educate, we advocate, and we litigate when necessary. We have a housing counseling component. Our homeownership program, Move to Opportunity, and financial literacy. Financial literacy is online, but the homeownership, which is down payment assistance and closing cost assistance, Move to Opportunity, those two programs are in the Richmond metropolitan area. Foreclosure prevention is statewide, so we do have counseling assistance for people who are facing foreclosure. Our policy and research team uses internal and external data to research systemic and historic housing discrimination, as well as to lead state and local housing policy efforts. So for our statewide services, that includes our Fair Housing Division, which is enforcement and investigation, foreclosure prevention, and our policy and research. So tonight we're just going to talk a little bit about fair housing. What is it? It's an idea that people can live where they want to live, free of discrimination. It is about embracing diversity and striving to create stronger communities. It's not about giving certain people special rights. It's about making sure that everyone has equal rights and equitable access to housing. Looking at the little item at the bottom with the apples, equality is where everyone has access to the apples, but not everybody can reach them. Equity, there are some changes that have been made to allow everyone to actually reach the apples. So equality promotes fairness and justice by giving everyone the same thing, but it can only happen when we all start from the same place. Whereas equity is making sure that people get access to the same opportunities, but recognizing that sometimes our differences or our history may create barriers to that participation. So the Fair Housing Act basically was passed April 11th, 1968. It was established to eliminate housing discrimination and promote residential integration. But unfortunately, well, for a while there, for many years, there was progress. But where we are today is we're worse off than we were in 1968. The law actually prohibits discrimination in the sale, rental, and financing of dwellings and other real estate related transactions. Those other transactions include homeowners insurance, homeowners associations, and condo associations. And that's also based on what's called protected classes, which I will go over shortly. The AFFH rule is basically a rule that was just set up in 2015, where the U.S. Supreme Court explained that much progress remained which was needed. So the localities and entities that receive HUD funding to promote fair housing choice It was the sort of a strong encouragement to say, be more proactive with what you're doing as opposed to just checking off a box, is primarily what it's saying. So what is housing discrimination and what might it look like? Well, refusing to rent or sell, different terms and conditions. It includes discriminatory statements or misrepresenting availability, intimidation, coercion, or retaliation, steering people to live in a specific area, or refusing RAs, RMs, and that's a reasonable accommodation or reasonable modification request from persons with disabilities. What might it look like? Requiring maybe criminal history background checks for only African Americans, or requiring that tenants speak English, refusing to accept tenants with housing choice vouchers or those that have other housing assistance, making derogatory or inappropriate remarks about a tenant's perceived gender, or allowing Christmas decorations and not Hanukkah decorations. And certainly, if someone retaliates against someone who takes action to enforce their fair housing rights. So as a fair housing organization, when someone calls us to complain or has an allegation of housing discrimination, there are certain elements to the case. First, of course, it has to be a housing transaction where someone feels like they have been discriminated against. And that is having to do with their membership in what's called a protected class. So what's a housing transaction? It could be renting a house, buying a house. Of course, it includes homeowners insurance, seeking housing assistance. It could be a community development activity, code enforcement, or zoning decisions, which are very, very critical with regards to the lack of affordable housing that we're experiencing in many communities, or any other housing related activities. The who and what. So what type of residential dwellings? Could be an apartment, could be a house, condo, mobile home, nursing home, group home, vacant land, or shelters. Who can be the violator? Can be an individual, could be an organization, association, corporation, could be a trustee, could be a public housing authority, or any entity that is defined as a person. So discrimination doesn't always happen with one person against another. It certainly can exist with traditions, beliefs, policies, ideas, laws, and certainly institutions. But no matter how it happens, the result is that people belonging to certain groups are not denied access to housing opportunities. So the federal protected classes include race, color, national origin, religion, sex, family status, and disability. Race, it's all races. Color has to do with the person's skin tone. National origin, that has to do with country of the origin or ancestry. And regardless of citizenship, a person, everyone's covered by this. You don't have to be a citizen of this country to be covered by the Fair Housing Law. Religion, that is the choice of religion or the lack thereof. Sex includes gender identity or sexual orientation. Also family status, families with children, or a person with a disability. And that's broadly defined as a mental or physical impairment which substantially limits one or more major life activity, or regarded as someone having a record of that impairment or being regarded as having such an impairment. And there are other protections for persons with disabilities, which I'll talk about in a minute. Additional protections in Virginia include elderliness, that's for persons 55 and older. Sexual orientation and gender identity are separate in Virginia. Actually, we had sexual orientation and gender identity as protections before the federal government did. Military status, that includes active military members or veterans, and that's veterans who have been honorably discharged. That also covers their families. Source of funds, that is a protection for persons who receive funding from some person or some entity that's provided on their behalf. So that's any source that is lawfully provide funds to or on behalf of a renter or buyer that might include any assistance, a benefit, or subsidy program, whether or not that program is administered by a government or non-governmental agency. There are some localities that have additional protections. I think Arlington, you might be one, Alexander, and I think Loudoun County. But there are a few other localities, particularly in Northern Virginia, that have additional protections. The additional protections for persons with disabilities include the RA, the RMs, and design and construction. The reasonable accommodation is actually a change in the policy laws policy rules or practices that a housing provider may have in place, but those to change that to accommodate a person with a disability, allowing them equal access and opportunity to enjoy their dwelling. An example might be to move to a ground floor for easier access. So if I'm a person with a disability I live on the second floor currently, something has happened and I have a mobility issue. There's no elevator and I need to move to the first floor. If there is a unit on the first floor that's comparable to where I live now, and I make that request, the RA, and one's available, I should be granted access to that unit. And when I move to that unit, that means that I don't pay any transfer fees. I don't have to make additional deposits, anything. I'm just moving from one unit to the next. Could be assigning an accessible parking space for a person with mobility impairment. It is amazing how many cases we have regarding accessible parking spaces in multifamily units. Adjusting the rent payment. This is something that many people are now becoming aware of. Because many folk receive their benefits beyond the 1st and the 3rd, it could be the 10th, could be the 15th. Because my benefits are received after the typical due date, so the rent generally is due on the 1st, it's late after the 5th. If I receive my benefits on the 10th, and so I'm consistently late, that's an accumulation of late fees, then legal fees, and now I'm a month behind. Well, to avoid that, the person with a disability can request a reasonable accommodation to request from the housing provider that my due date be changed to accommodate, to coincide, I would say, with my benefits, the receipt of my benefits. So I will request, if I get it on the 10th, I'd like my payments be due on the 1st and late after the 15th, or considered late after the 15th, allowing me the same 5-day grace period as everyone else. We've recently had a case like that where the housing provider denied the tenant the opportunity to change his scheduled date. It was about 6 to 9 months on that case. We won that, and the housing provider had to change the date, and he had to return the late fees to the tenant that he received during the whole process of the investigation. To break a lease without penalty, if I'm no longer able to live in the apartment or my unit. If I need to move to the ground floor and there's no unit available, then I may need to end my lease. Even though there's 6 months left on the lease, if I can't live there any longer, then I make a reasonable accommodation request to leave the unit, and I am no longer responsible for the remaining portion of that lease. A reasonable modification, that is a change to a structure with regards to a person of disability to allow them the same, again, opportunity, the use of enjoyment of the dwelling like everyone else. It may include grab bars, replacing round knobs with pull knobs in the kitchen or entrance areas. People who have arthritis or problems with their hands have a tendency they do better with pull handles than round knobs. I may need a wheelchair ramp. I may need carpet removed. The issue with the reasonable modification is that the cost of it is going to be the tenant's responsibility. And it is okay for the housing provider also to ask for funds to be put in an account so that when me as the person with a disability, when I leave, I can return the modification back to its original state. And that's only if the next person who lives in this unit cannot use it, or it's not going to benefit them at all. So say for instance, if the carpet was removed because I now have a rollator and hardwood floors are put in, it makes no sense to ask me to put the carpet back if the person who's coming behind me, hardwood floors would be fine. If the property that I'm living in receives any federal dollars, then the cost of the modification is then the responsibility of the housing provider, unless that housing provider can prove that this request or change would present a financial or administrative burden. And then it's still up to the housing provider to come up with some other solution. There are accessibility grants at Virginia Housing where renters and actually homeowners can receive up to $8,000 to assist with some type of structural damage, structural change. Design and construction, that has to do with buildings that were constructed after March 13th, 1991. There should be their accessibility issues, entrance and all accessible routes, accessible public and common use areas, usable doors, et cetera, et cetera. When you see a new building being constructed, it's not, you can't always assume that the guidelines have been followed. We had this happen a couple of years back in Richmond, brand new complex, 340 units. And once the complex was complete, we went in to look at the unit, measure to make sure that it was accessible for a person with a disability, and found that there were many violations. So we confronted the developer, which was a well-known developer, about the issues, and they told us that, well, it would be too expensive for us to change that. And our response was, well, you should have known better. That's on you. So it turns out that yes, it did cost them quite a bit of money, but hopefully next time they have another project that big that they will follow the law. So we can't always assume everyone is paying attention. Our top complaints at home are disability, which number one, disability is number one across the country. And that's with any entity that is actually taking fair housing complaints. That would include other private fair housing organizations. It includes HUD, Department of Justice. Disability complaints are always number one. And for us at home, race used to be number two. But since source of funds became a protection in 2020, it has taken that number two spot. With regards to disability, the most frequent complaints come in having to do with service animals or emotional support animals. So oftentimes it's knowing the difference. A service animal is a trained animal that provides some sort of service to that person with a disability. Generally, we think of a guide dog for a person who's visually impaired, or an animal that would help a hearing impaired person alarm them to sounds or alarms. There are service animals that alert people who are having seizures, but they perform some type of service for that person with that disability, and they are trained. The difference with an emotional support animal is that an emotional support animal does not need or require any type of special training. And the animals vary. It could be a cat, could be a dog, could be a rabbit. We had a case several years ago where it was a 4,000 ton, it was, I think it was 4,000 or 4-ton pig. It was a huge pig. I remember that. for this little girl. That was her emotional support animal. And she lived out in the county, and the property owner didn't want the animal there. But we won that case, and she got to keep her pig. But the point is, with emotional support animals, they provide support or companion to that person with a disability. Because all disabilities certainly are not necessarily obvious. It could be a mental impairment. It could be this emotional support animal, which we call ESAs, could be there to help me with panic attacks or help me cope with mood swings. The other important piece with this is that there's no breed, size, or weight restriction for emotional support animals. What we hear often, particularly in multifamily property management, is that someone may request an emotional support animal and it's a particular breed, and management will say, well, it's not us that will not allow you to have this particular breed. It's our insurance company. Well, it's up to the housing provider to let the insurance company know the law. And if the request is not made, then a person with a disability, then I can file a suit against the housing provider and the insurance company. It is my responsibility, of course, as the owner of this ESA to make sure that my ESA is not disturbing other tenants, that I take care of this animal, that when I am out with the animal, if it is, say, for instance, a pit bull and it is intimidating to other people, I need to make sure that I am careful where I walk my dog, where I have it, to protect my neighbors. That is my responsibility as the owner of this ESA. Now, the housing provider is entitled to require or ask me for information to evaluate my need or the necessity for this RA or RM. If my disability is something that's very obvious, there's no need to ask me why. If I'm in a wheelchair and I'm requesting a wheelchair ramp, there should be no question why I need it. If so, that could be seen as intimidation because you're asking me something that's very obvious. In many cases, a disability is not so obvious. And so the housing provider really can only request information that's necessary to evaluate the request, meaning that detailed medical information is not needed. And that information can also come from a medical provider. It doesn't have to be a medical provider. It could be from a peer support group. It could be from a therapist. It could be from some reliable third party or somebody who's familiar with that person's disability. And in most cases, I would say 99% of the time, certainly detailed information is not needed. And if requested, that is truly inappropriate. Before I go to types of discrimination, are there any questions thus far?
Any questions from commissioners?
I have a couple.
Okay.
You mentioned an example earlier, in reference to, language, discrimination
Yes.
on language. Is that, I was just curious, is that fall under one of the protected classes somehow? So I can't really figure out which one it would.
Because that would have to do with national origin. That would fall under that category.
Okay, all right.
And I will say that there are, particularly in a multifamily complex, and there are several, and we've had a couple of cases like that, where they may be receiving some type of federal assistance.
Sure.
If a housing complex is receiving federal assistance, first of all, you're required to provide translators for persons who don't speak English.
Right.
If you're going to rent to them.
Yeah, I was just curious. We hear about different languages quite a bit, and I didn't really understand where that authority came from. So that makes sense. Thank you.
Yeah, falls under national origin.
I I was also curious, when you win these lawsuits, is there a fee shifting provision in the law that requires the owner or landlord or whoever violated the law to pay your legal fees?
Pay the legal fees from the lawsuit. Well, generally they're in the settlement, whatever that settlement is. Um, legal fees generally are included in it.
Okay,
Okay, yeah. So, and I'm going to talk a little bit about disparate impact, in criminal history. Like with criminal history is not a protected class, but the disparate impact theory is used when we're doing those cases.
sure.
I did a case some years ago with a condo association in Virginia Beach, and the one of the owners there was denied her ESA, her emotional support animal, and the condo association had to pay her $93,000. That didn't even include the legal fees.
Yeah,
That's what she received. So whatever the final settlement is, legal fees come out of that.
yeah, understood. That makes sense.
Okay. So with the type of discrimination, we talk about intentional, which means that you just mean to treat me unfavorably. Disparate impact is when a policy or practice has an unjustified discriminatory effect on a certain group of people. So even though the rule is there and it's across the board, it may affect or have a negative effect or impact on a protected class, even though, it's something I didn't mean to discriminate, but that's just how it turned out. And of course, the refusal to provide an RA and RM is discriminatory. But with regard to disparate impact, criminal history is a perfect example. Like I said before, having a criminal history is not in a protected class, but a disparate impact theory is used. So when we look at this slide here, the likelihood of imprisonment of U.S. residents born in 2001. So all men, 1 in 9, white men, 1 in 17, Black men, 1 in 3, Latinx, 1 in 6. Same kind of scale for women. So when folks are returning citizens, who's likely to have more of an issue finding housing? So when we look at 2001, look at even more recent here, 2021, 2019. This is Virginia specific. The last slide had to do with the entire United States. This is Virginia. Things have not changed. It looks basically the same. And if anybody in the room can remember the war on drugs in the 1970s, this is a result of that, which when you read about really what that was about and how it came about, it was not true. It was all a lie, but it certainly has continued since 1970. Prior to 1970, between 1930, 1957, 60, 65, the incarceration rate was pretty steady across all ethnicities. But in the 1970s, it escalated, particularly for people of color, and it has not changed since then. So I would suggest if anybody doesn't know about the war on drugs, and you can go in and check to see what we're looking at now, how that all happened. So there is guidance actually from HUD as to how you screen someone or how they should be screened when applying for housing. It is unjustified to ask for, denying someone housing because of an arrest record is insufficient. There should not be blanket bans. We see applications that say we will accept someone with a criminal history, with a felony is what it says, as long as it has not been within 99 years. That is a blanket ban. And we've had some cases where we've gone into correct that. And actually, it was a complex out in Chesterfield that we did. We had a case like that probably about 10 years ago, and they had a blanket ban. And once we completed that case, and once the investigation was over, in that settlement, we actually had enough money, or we set aside a pool of money to pay, I think, people who had applied for housing for the past 24 months. We had enough in the settlement to give them some of that, where we were able to share it with them. But anyway, what should be done is a personal assessment. What crime was committed? When was it committed? How long it's been since it occurred? The age of the person when it was committed, that crime was committed, or any changes in that person's situation since the crime occurred. A reasonable accommodation might be used. This is in a situation generally when someone who is a returning citizen, and they actually were incarcerated because of some crime that occurred when they were they had a drug addiction. And so oftentimes people who have drug addictions, they've been on drugs for a while. Now they have rehab, and they're living their life in a different way now. And sometimes they are a person with a disability now. And so sometimes a reasonable accommodation request might be made, because what your guidelines say is that what your policy, your criminal history policy, which all housing providers should have, and many times they don't. But if your policy says that we will accept anyone who has a criminal history, as long as it has not been within the last 3 to 5 years, or 3 years, or 5 years, which is what we see more often. If it has been within the last 5 years, and say my criminal history, it was less than 5, but because the crime I committed was it was done during the time when I was addicted to drugs, then a conversation should be had. I don't need to be punished for the rest of my life for something that really I was not in control of at that time. So anyway, but we've had that to happen as well. What's also important is that discrimination can happen in any phase of the housing process. Could be the application process, where you're applying for an apartment, you're buying a house, applying for a loan. Could happen during tenancy. It could happen at the termination of tenancy. What's important is that you can file a complaint up to 1 year after the last incident. So if I've been in my unit, say, for 6 months, and there's something going wrong, and I've been treated unfairly by management, say, for instance, and this continues and for the next several months. At the end of my lease, I decide I'm not going to rent. I have to leave. Just because I left that location, and this discriminatory action kind of sort of continued through till the end. When I left, I can file a complaint 1 year after I left, not when it first started, but when the last incident occurred. So where you file a complaint, certainly with Home of Virginia, with VFHO, with the Virginia Fair Housing Office, and also with HUD. I will say right now with HUD, they have changed their intake process. So I'm not sure where things go with that right now. So, but I don't say that, someone shouldn't apply or complain or send their complaint that way. But I think that certainly working through Home or VFHO might be a better choice. To file an administrative complaint, again, you can do it 1 year. You have 1 year to do that. If you file a lawsuit, you actually have 2 years to file suit against the violator. The way it happens is that you complete the form, which is really not complicated. To start a complaint, it's basically saying who you are, where you live now, if you still live in the same place, where did this discrimination occur, who actually discriminated against you, who violated your rights, And it was based on what protected class. Why do you think, this discriminatory, how did it affect you? Was it because you had children? Was it because of your skin tone? Was it because of your gender or your membership in the LGBTQ plus community? Just give us some basics. It doesn't have to be all the details. Um, every time you file a complaint, mediation is always offered to determine whether, can we settle this now? If that can't happen or doesn't happen, the investigation continues. Certainly throughout the investigation, mediation is always an option. And then, of course, at the end, once the investigation is complete, this is if it goes through VFHO, then the Fair Housing Board makes a decision where they cause it or no cause it, meaning that if it's caused, meaning there's enough information to say that yes, discrimination occurred, and then it goes to court. If they no cause it, that means that they don't have enough information to say that discrimination actually did occur. Even at that point, a person can appeal that decision if it's no caused. But the point is, if we do it ourselves, because we do have attorneys in our office, basically it's going to go to court. And that's our way of doing things. Now, one of the things that we do use certainly is testing. It's a simulated housing transaction gain. Certainly, it's used to gain evidence of a potential discrimination case. We know it sometimes as secret shopping. And this is where we send out match pairs, depending on what the situation is. Those pairs go out, they have an assignment. It could be in person, could be over the phone. And that person goes out, they do what they've been assigned, they report back to the test coordinator, and we use that information to compare and look at what information we receive. And it can, like I said, it's been very, very useful to support a particular complaint, or it has definitely been valuable. It's been used for years and years and years. And actually with testers, when someone goes out as a tester, we always need testers from all backgrounds because of all the protected classes. But when a tester is harmed as well, and oftentimes that's what's going to happen if we find that there's evidence, a tester can also be part of the settlement. Should the settlement come out and you testify, you would actually be you would receive benefits as well from that settlement. So a little bit difference between fair housing law and landlord tenant law. Fair housing law refers to, of course, the differential treatment based on someone's membership in a protected class, where landlord tenant law really applies. It's a contract between the landlord and the tenant. And you see the examples there. Landlord tenant law, where the landlord will make repairs for anybody. If it's a fair housing issue, some of the landlord won't make repairs for specific people. Sometimes, even though it's a landlord tenant issue, it may have a fair housing. There may be something going on with a fair housing violation as well, and vice versa. And sometimes it's both. Just a little bit about evictions. Evictions and fair housing. Well, first of all, evictions are a voluntary move initiated by property owners. Generally, it's done because somebody has violated the lease. And more often than not, it's when somebody's not paid their rent, or they have violated some other part of the lease. Well, there are formal court proceedings which should take place, but they're informal evictions as well. And for every formal eviction, there are 2 to 5 additional forced rental moves, meaning that oftentimes people either self-evict or they're responding to a housing provider's notice. The housing provider sends a notice, I want you gone in 30 days. Sometimes people respond to that, not recognizing that the housing provider can't just send you a letter. That's not enough. You have to go to court. You have to be able to present your side to court as well, or say what is happening on your end. I always tell people, always go to court. Even if it's for non-payment and you don't have any money, at least go there. Sometimes things can be worked out. But oftentimes, a housing provider will sometimes do things like stop making repairs when they want somebody to move, or they may begin to harass a tenant. And that harassment, remember I talked earlier about intimidation, coercion, or retaliation. That would fit in to a discriminatory act against that person. You are harassing me because you want me to leave. You want me to leave, you need to go and through the formal process. And sometimes people harass some people and they don't harass the others. But anyway, it's the informal process that sometimes so many people leave without even due process. They don't go through the courts. With regards to fair housing and the intersection of fair housing and evictions, annual eviction filings among Black adults living with children surpassed 25%, well over double the risk faced by other groups, as you see in this slide. African American families living with children are evicted more often than any other ethnic group. When you look at income, so there's a higher income, less eviction. Well, true. Eviction risk declines with income, but the racial disparity is still large. Within every income category, Black renters, particularly those living with children, are at a greater risk of eviction than their white peers. As you see here, with the blue line here for Black residents, for all residents, for white residents. The gap is there. And that is just not something that just happens. That's oftentimes by design. Landlord tenant laws. Oftentimes landlords do not keep up, landlords or tenants keep up with the changes with the Virginia Residential Landlord Tenant Act. I list these because these are particular laws that either went into effect July 1, 2024, or some of them actually have been in effect since 2020. I'm going to send out the details of this sheet to Kara. I want to keep saying, is it Kara? I don't want to call you wrong. I'll send it to her so you guys can have that information, because oftentimes it's like, oh, I didn't know this existed. I did want to share something that I see more often than not, and that has to do with repairs, that tenants are not aware of their options when it comes to repairs. Well, there has always been the option of, or for a long time, a tenant's assertion. That's when a person, some people know it as putting monies in escrow. When you notify the landlord of a particular issue, certainly that's something that is could be life-threatening. It is something that needs to be repaired. The landlord's not doing it, so then you complete the paperwork and you actually pay it to the court until the repair is complete. Sometimes the landlord doesn't comply and they will not do it. The court will say, you have excellent, well, it should be done within, 60, 90 days, sometimes 120. If it goes beyond 6 months, which I've known some cases where that happened, and me as the tenant then go back to the court and say, this is still not corrected, then I can, oftentimes the court will say to the tenant, well, they will grant them the authority to leave and not owe anything. And they give all the money that's been put in this escrow back to the tenant. I've seen that happen. The other one is repair and deduct. I think this went into effect in 2020. Repair and deduct is where me as the tenant, if there's a problem and I want to make the landlord is not making the repair, and I say, okay, I'm going to do it myself and subtract it from next month's rent. For the longest time, of course, you could not do that. But now you can. Still have to notify the landlord that the repair is needed. Giving them time to do it, and time would mean it could be 7, 14 days, whatever you think is reasonable. And if that's not done, then you can hire a contractor to make the repairs, and whatever it costs, it cannot exceed $1,500 or 1 month's rent, whichever is greater. And you can subtract that from next month's rent, and it is within the law. The other option is you can write the landlord a letter describing the repair, and you can give them what's called a 2130. Generally, a 2130 coming from a landlord in the past has been landlord only. The landlord would send a 2130 to me, the tenant, to say you're violating the lease in this way, and you must correct it within 21 days, or you have to leave in 30. Now, the tenant has that option. Is I can say that with the repair, if this repair is not done within 21 days, then I will be able to leave in 30. And I'm not then responsible for the remaining portion of the lease. The problem now, of course, that, finding some place to live that's affordable or that's comparable to where you are may be the issue, but it also depends on what the repair issue is. So here are some resources. I'm going to also, I think you guys have this PowerPoint. If you would take out your phones and just scan this QR code, and it's an evaluation form. I think it's about 5 or 6 questions. Kind of check the box. It was something was helpful, something that you could share. What things might you change with this particular presentation? Or if something you enjoyed. So I'm going to assume that everybody has the phone out and have had a moment to no. You guys
Yes.
let me know. Does everybody have the survey up?
Yeah.
Yes.
Okay. So I'm going to stop sharing, okay? And again, my information is in the PowerPoint. It's on the first page. And this is, of course, our information. I would suggest that any and everybody who's listening or get a chance to hear this, go to our website and look at the work that we're doing, look at some of the cases that we're working on, look at our housing agenda, some of the things that we have been working on with legislature. Actually, let me stop sharing. I would say that with our policy team, this year's housing, let me see, can I put my camera on so y'all can see me? Okay. This year we had some really, really good housing. We call it our bills. We reach out to legislators to say this is what we're seeing, and here's some information we'd like you all to put into a bill. Well, we had a really strong agenda this year. We had bipartisan support on all of our bills. Everything went well until the governor vetoed all but one. And we had something in there. We had a lot of support for a bill having to do with anti-gouging, which was absolutely wonderful. But that was vetoed as well. So, we keep coming back year after year and trying to, Virginia has for long been landlord friendly. Although many landlords would not think so, but it's very landlord friendly. And we want would like things to even out. But like I said, we look at internal and external data to come up with what we think should be laws going forward. Anybody got any questions or any discussion or?
Commissioners, any questions?
No, I think the only thing, this is Adrian, by the way, the only feedback that we have for this, as landlords, we do have to go to fair housing seminars. And I think one thing that is very impactful in those seminars is, once you describe the protective classes, to also associate the examples of a case and how much money or, or what was the lawsuit according to that actual protected class happens. I think that's very impactful for people to understand that, they need to get their stuff together. They need to learn this because it's not just the law that some people hope that tenants don't know, but
Right.
that's a lot of money. And I think that's
Well-
my only feedback, putting that there. It's very impactful because,
And I
for us-
will say that there sometimes, and I know you guys had other things going on in this meeting, but I oftentimes when, depending on who I'm talking to, if I'm talking to a landlord group or some housing providers, I do include that
Yeah.
because I have lots of cases, particularly I have a lot of cases for sexual harassment. God knows I have a lot of those. And a lot of cases having to do with zoning. A lot of cases, I mean, there are many cases for every protected class. And you're right, sharing those dollars. Like I said, with the ESA, the one that I worked on, it was $93,000. For another one, a local, it was in Chesterfield County that I worked on. The Fair Housing Board no caused the emotional support animal the rejection of the RA, which I don't know how that happened. I thought it was enough evidence, but I wasn't on the board. But they no caused it. But what they did cause was because once the lady filed a complaint, the landlord harassed her throughout the entire investigation. He called her, he texted her, he would stop by the house. It was crazy. So they no caused the denial of the ESA, but they caused the harassment. And then he had to pay her $30,000 for acting a fool. You know what I'm saying? So yeah, yes, he did. He had to pay her $30,000 with the criminal history case that I worked on. That was in Northern Virginia. This was about 4 years ago when I was on the fair housing team. And this lady was denied housing. Now, it was the husband was in the apartment. They had been separated, so she came back to live with them. They had one child. She had been there for 3 years. Everybody knew her. She was no threat to the community. They became pregnant. They applied for a 2-bedroom apartment. When they applied, they were denied because of her criminal history, which was 10 years old. So what was the issue there? Of course, so she came to us. We worked on that case. Because criminal history is not a protected class, we couldn't go to the Virginia Fair Housing Office. At that time, we didn't have fair housing attorneys that could do cases on staff at that time. So we hired a firm out of DC. It took about 18 months, but that particular housing provider, of course, they had to move somewhere else in Northern Virginia, but that particular housing provider, so we won that case. They had to, of course, create a criminal history policy. They had to train, of course, their staff, not just the the management staff, but all staff, maintenance and everybody. They had to be monitored for 2 years based on who they accepted and didn't accept. Plus, they had to pay this family $40,000. Now, that's what went to them. I don't know what went to the attorneys, okay? This family took that $40,000, moved to North Carolina, and they bought a house. So there's some really good outcome. Most cases that I worked on when I was on the fair housing team, they vary between $5,000 and $30,000 every case that was won. So you're right. There's so many examples out there, and I do often share that. So I'll remember that to put a few more cases in with the settlement.
And that's not even necessarily talking about like a settlement before a decision is reached, right? Like in a mediation setting where they agree to drop the case in exchange for some amount of money.
Right. Now that does happen. I had a few cases myself where the mediation actually was successful, where the property owner said, okay, I don't want to go through all of this, let's just come to the table and, whatever was needed, they worked it out. And maybe, that person may have settled with, a couple of $1,000s. So at me as housing provider, when I look at where this thing is going, I might say, okay, we can settle this and you can have your ESA, but we can do something else. And I'll pay you $2,500 right now. We can have it been over with, as opposed to me paying you $10,000 should we have to go further. We've actually had a case where this lady in Richmond, she was a housing provider and she was so mean. I will just say that she was just mean and ugly, okay? But she was mean to people who had children. She was so, mean. When we went out testing, and when we do testing, oftentimes when it's in person, people have recorders. They're wired, right? She said some of the most vile things to folks. At the end of that case, once we finished with that, she had probably maybe 8 properties, and that went to court. She was ordered not only to pay the folks who the initial complainant, and we found some other people who she had treated that way to be part of this lawsuit. The judge made her sell all of her property. All of it. She had to sell everything, which I thought, that was good. That's what she needed to do. I'm sorry about my little light over here. I'm at my daughter-in-law's house, and Alexa, she has everything with, is that her name, Alexa? When you talk to her, right? And Alexa and I don't get along. And so I can't figure out where the lights are. But anyway, yeah, I thought that was strong. I had never seen a case like that where the judge ordered that she sell all her property. So she ended up with nothing. Well, it wasn't a really kind of sad thing, because I think 2 years after that case, after she had to sell everything, she also passed away. But, such is life. I'm sorry. Things happen, could be karma, or I don't know what you call it. But I will say that if the information that I shared today, if anybody would like more information, or if you want me to come out to speak to a landlord group, or even a tenant group, at any event, just give us a call. Now, I say call us. I'm hoping that they'll reach out to me, because I'm retiring in 15 days. Can you believe that? I'm so excited. After 38 years with this agency. So, but I have agreed to work part-time because I really enjoy going out to share this information, reaching out around the state, because I've been doing the outreach for the last 4 years. Most people don't know what their fair housing rights are. They have no clue. And so just to talk about it and have people know their rights. And it's not also just about knowing your rights, it's knowing who to call when problems come about. Because just like the guy who was there today, I couldn't hear a lot of what was happening, but part of the issue is, who do I call? Who do I tell this to? Who can help me with this situation? And sometimes, when people can't find, they don't keep going, they give up. There's always somebody out there to help you do something. So anyway, I could talk all day. I know it's almost time for y'all to leave.
Well, thank you so much for such an informative discussion, and good luck on your next endeavor into retirement. And thank you for all your work in the space.
Yes, thank you.
Thank you.
Absolutely. And like I said, I will send out that landlord-tenant, the landlord-tenant laws, the updates that I talk about in the, listed. I'll send you the details of those.
Awesome. Thank you.
You're welcome, guys. Take care.
Thank you. Have a
you.
good evening.
Bye.
Moving on is staff reports. Kara, the floor is yours.
No staff report. Hector, do you have any staff reports?
No, I don't.
Okay, sounds good. Moving on, I think there's only one more item, which is adjournment. So is there a motion?
So moved.
Motion to adjourn has been moved, is seconded, moved and seconded, all those in favor? All those opposed? Okay, this meeting concludes at this hour. Thank you all for joining and see you all next month.